Many real estate transactions involve title insurance. But is title insurance meant to protect only against title defects visible in the public records, or against all title defects? The Georgia Court of Appeals answered this question in Keyingham Investments versus Fidelity National Title Insurance. Michael Shanahan owned a piece of property. A person pretending to be Shanahan took out a mortgage loan on the property. 3 lenders agreed to jointly loan $106,000 to the fake Shanahan, with the property as security for the loan. The lenders went to Fidelity National Title Insurance and asked it to issue title insurance to them for the mortgage transaction. In a document known as a commitment, Fidelity promised to issue a title insurance policy to the lenders after certain conditions were met. One condition was that specific documents be signed and recorded. The commitment described these as, quote, documents satisfactory to the company creating the interest in the land and/or mortgage to be insured, unquote. Fidelity's agents handled the loan closing process. After showing forged identity documents to Fidelity's agents, the fake Shanahan signed a security deed that supposedly gave the lenders a legal interest in the mortgaged property. Satisfied with the loan documents, Fidelity's agents had the documents recorded. The lenders paid Fidelity the premium for the title insurance policy. But before Fidelity issued the policy, the loan went into default, and the fraud was discovered. Fidelity then refused to issue the title insurance policy. The lenders and Fidelity disputed whether the commitment's conditions had been met, and therefore whether Fidelity had a contractual obligation to issue the policy and to pay for the loss caused by the fraudulent security deed. 2 of the 3 lenders assigned their claims against Fidelity to Keyingham Investments. Keyingham and the 3rd lender sued Fidelity. They argued that Fidelity had promised to issue a title insurance policy if Fidelity was satisfied with the loan documents, and Fidelity, through its agents, had been satisfied with the loan documents. Fidelity argued that the commitment's language required it to issue a policy only if the closing documents created a valid interest in the land. Because the forgery meant that no valid interest had been created, Fidelity believed it wasn't required to issue a policy. However, Fidelity conceded that, if issued, its policy would cover the forgery loss. Both sides moved for summary judgment. The trial court entered judgment for Fidelity, ruling that Fidelity wasn't required to issue the policy. Keyingham and the 3rd lender appealed to the Georgia Court of Appeals.